Kinds of jurisprudence. Austin divides jurisprudence into two parts, namely general jurisprudence and particular jurisprudence. By general jurisprudence, he meant the science concerned with exposition of the principles of notions and distinctions which are common to all the system of law, whereas particular jurisprudence consisted of science of any such system of positive law as now obtains and once actually obtained in specifically determined nation. This classification by Austin has been criticized by many jurists as being unscientific and impracticable. Holland argues that it is vague to think of general jurisprudence. According to him, science is science and it cannot be classified as general or particular. Criticism. Criticizing Austin's concept of general jurisprudence, Buckland observed that even those who professed his view, including Austin himself, did not adhere to it in practice. Dias and Hughes characterized Austin's definition of general jurisprudence as it lacked amplitude and maturity in the prevailing legal system. According to Dr. Allen, jurisprudence is the science of synthesis of essential scientific synthesis of the essential principles of law. Though the definition may seem to be abstract at a glance, it surely takes notice of the widening scope of the law in its various facts. According to Patton, jurisprudence is a particular method of the study not of the law of one particular country but of the general notions of law itself. Patton is of the opinion that jurisprudence studies the basic or fundamental principles or general notions of law itself. It does not study the law of any particular country. For example, there are certain basic principles: possession, ownership, property, rights, duties, obligations, title and person, etc. And they are essential elements which are not studied in any particular act but in jurisprudence. Thus, this special subject matter of study is called by jurists as jurisprudence. Jurisprudence, therefore, is not merely the knowledge of law, but it is a systematic and scientific study of the fundamental principles relating to law. Conclusion. In short, on the basis of the above description, we can say that the Salmond statement that jurisprudence is the science of the first principles of civil law appears to be more sound than any other definition, because in fact we study the basic principles of law in jurisprudence and not the law of any particular country. Patton is also of the same view.